The rat infestation in Autun, France, was unbearable. So in 1522, the town took legal action. They put the rats on trial. When the rats failed to appear in court, the judge appointed them a defense lawyer who argued his clients couldn't attend due to the dangers of cats on the journey. The judge found this reasonable and granted safe passage. The rats still didn't show up. They were tried in absentia and sentenced to exile. The strangest part? The townspeople believed this worked. Hey there. Tonight we're entering the bizarre world of medieval animal trials, where for over 500 years, European courts seriously prosecuted pigs for murder, excommunicated insects for destroying crops, and appointed lawyers to defend rats against charges of theft. This isn't folklore or satire. These were real legal proceedings with real judges, real lawyers, and very real executions. If these stories help you drift off, feel free to like and subscribe. Let me know where you're listening from and what time it is. Now dim the lights, get comfortable, and let's explore why medieval Europe spent centuries putting animals on trial for crimes they couldn't possibly understand. Part 1. The Legal Foundation. Savigny, France, 1457. A 5-year-old boy is found dead, his face partially eaten. The culprit is quickly identified, a sow and her 6 piglets. But this isn't a simple case of destroying dangerous animals. This is a murder case. The pigs are arrested. Actually arrested. They're taken to the local jail, where they're held alongside human prisoners. The jailer charges the same fee for their upkeep as he would for human inmates. A trial date is set. The court summons witnesses. A prosecutor is appointed. And, crucially, a defense lawyer is assigned to represent the pigs. The trial proceeds exactly like a human murder trial. Witnesses testify about what they saw. The prosecutor argues for the death penalty. The defense lawyer, yes, seriously, argues that while the sow is clearly guilty, the piglets were merely following their mother and should be shown mercy. The judge deliberates. His verdict: the sow is guilty of murder and sentenced to be hanged by the neck until dead. The piglets are acquitted due to their youth and the corrupting influence of their mother. The execution takes place in the town square. The sow is dressed in human clothes, a jacket and breeches. The executioner is paid his standard fee. The crowd gathers to watch justice being served. This wasn't unusual. This was normal. Between 1200 and 1700, there are recorded accounts of at least 200 formal animal trials in Europe. Pigs tried for murder. Horses tried for homicide. Bulls tried for assault. Rats tried for theft. Insects tried for destruction of property. These weren't mob justice or superstitious rituals. These were formal legal proceedings following established law. Part 2. The theological reasoning. Why did medieval Europeans believe animals could commit crimes? The answer lies in medieval theology and philosophy. According to Thomas Aquinas, all creatures existed within God's moral order. While animals lacked rational souls, they could still be instruments of divine justice or demonic influence. If an animal killed a human, it had violated God's natural hierarchy. Genesis 9 verse 5 stated, "And surely your blood of your lives will I require. At the hand of every beast will I require it." This was interpreted literally. Beasts could be held accountable for shedding human blood. The medieval scholar Philippe de Beaumanoir wrote, "When an animal commits a crime, it acts against a natural order established by God. Though lacking reason, it becomes an instrument of evil and must be punished to restore divine balance." Animals could also be possessed by demons. A pig that killed a child might be acting under satanic influence. The trial and execution weren't just punishment, they were exorcism. The church supported this view. Pope Stephen VI had actually put a corpse on trial in 897, the Cadaver Synod. So trying living animals seemed reasonable by comparison. Canon law distinguished between animals acting naturally and those acting unnaturally. A wolf killing sheep was natural. A pig killing a baby was unnatural and criminal. Part 3. The notorious pig trials. Pigs were the most frequently prosecuted animals. Why? They lived close to humans, roamed freely in medieval towns, and were omnivorous. A hungry pig would eat anything, including unattended children. The case of Falaise, 1386, is the most documented. A sow had eaten the face and arm of an infant, The pig was arrested, held in jail, and tried for murder. The trial transcript survives. The prosecutor argued, this sow, with malice aforethought, did willfully and feloniously attack and kill Jean Lameau, aged 3 months, showing a depraved indifference to human life. The defense lawyer argued diminished capacity. The accused, being a beast, cannot form criminal intent. Her actions, while tragic, were guided by instinct, not malice. The judge rejected this defense. The law requires that any creature, rational or irrational, that kills a human must answer for it. Ignorance of the law is no excuse. The pig was sentenced to be hanged. But first, it was tortured. Its face and arm were mangled to match the injuries it inflicted on the child. Then it was dressed in human clothes and hanged in the public square. The execution cost 10 sous and 10 deniers, itemized in town records. 6 sous for the executioner, 2 sous 6 deniers for a new rope, 2 deniers for gloves for the executioner, cart rental to transport the pig. A painter was commissioned to create a fresco of the execution in the Church of the Holy Trinity. It remained there until 1820. Part 4, the insect trials. Even more bizarre were the ecclesiastical trials of insects and rodents that destroy crops. In 1478, the canton of Bern tried field mice for destroying the harvest. The mice were assigned a defense lawyer named Hans Grimner. The proceedings were formal. The prosecution presented evidence of damaged crops. Witnesses testified to seeing the mice in the fields. Grimner's defense was creative. My clients are God's creatures, placed upon this earth before humans. They have prior claim to the fruits of the field. If they take what humans consider theirs, it is not theft but exercise of natural right. The court wasn't convinced. The mice were ordered to leave within 6 days or face excommunication. When the mice didn't leave, obviously, they were formally excommunicated. The priest read the sentence in the fields. We curse you, detestable mice, in the name of Almighty God, and command you to depart from these fields immediately. Did it work? The records claim the mice left. More likely, winter came and the mice died naturally or moved to warmer locations. But the town credited the legal proceedings. Part 5, the great lawyer Chassenée. Bartholomé Chassenée became famous defending rats in Autun in 1522. The rats were charged with destroying the barley crop. The ecclesiastical court issued a summons for the rats to appear. When they didn't show up, Chassenée argued they hadn't been properly notified. The court agreed and ordered the summons read from every pulpit in the affected parishes. The rats still didn't appear. Chassenée then argued his clients couldn't come because of the distance and dangers involved. Cats made the journey perilous. His clients had a legal right to safe passage. The court ordered all cats to be restrained on the trial date. Still no rats. Chassenée's next argument. His clients were scattered across multiple jurisdictions. A single summons was insufficient. Each rat colony needed individual notification. Then he argued many of his clients were nursing mothers who couldn't leave their young. Finally, he questioned the court's jurisdiction. These were ecclesiastical matters, not criminal. The appropriate remedy was prayer, not prosecution. The court eventually dropped the case. Chassenée's reputation was made. He later became a prominent jurist and wrote influential legal texts. His successful defense of rats was considered a masterpiece of legal reasoning. Part 6, the execution methods. Animals were executed using the same methods as human criminals, matched to their crimes. Hanging was most common for pigs, dogs, horses, and bulls that killed humans. Burning at the stake for animals accused of sorcery or unnatural acts. The rooster in Basel that allegedly laid an egg was burned because laying eggs was considered satanic for male birds. Burial alive for animals that committed crimes underground. Moles destroying crops might be buried. Drowning for animals whose crimes involved water. Some executions were elaborate. In 1394 Mortain, a pig that killed a child was hanged from a gallows while dressed in a man's clothes, with a mask resembling a human face placed over its head. In 1553 in Beaune, a cow was hanged until nearly dead, then cut down and beaten to death, the same punishment given to human traitors. The executioner was always the official town executioner. He received a standard fee, whether executing human or animal. Being an animal's executioner carried no shame. It was considered part of maintaining divine justice. Part 7. The defense strategies. Defense lawyers took their job seriously. They developed sophisticated arguments. Lack of jurisdiction. Animals belong to ecclesiastical courts, not civil. Or vice versa, depending on what helped the client. Insufficient evidence. How could witnesses be sure which specific pig among many was guilty? Act of God. The animal was fulfilling divine will, punishing human sin. Natural right. Animals had lived in the area before humans. They had prior claim to resources. Diminished capacity. Animals lacked reason and couldn't form criminal intent. Necessity. The animal was starving and acted from desperate need. Improper procedure. The summons wasn't properly served. The animal wasn't allowed to face its accusers. One lawyer argued his client horse couldn't be guilty of homicide because it had iron shoes. The iron prevented demonic possession, so the death must have been accidental. Another argued that executing a pregnant animal violated the principle that innocents shouldn't suffer for others' crimes. These arguments were made seriously, cited precedent, and sometimes succeeded. Part 8. The witness testimony. Witnesses in animal trials testified under oath, just as in human trials. A typical testimony from a pig trial in 1494. I, Marie Bourget, swear before God that I saw the accused so enter the house of Jean Moreau. I heard the baby cry. I ran inside and saw the sow with blood on its snout, standing over the injured child. The sow showed no fear when I screamed, but continued its attack until beaten with a stick. Character witnesses appeared too. Neighbors might testify that a pig had always been aggressive, or conversely, that it had been gentle until this incident. In one case, children testified that a pig on trial had played peacefully with them, suggesting the attack was out of character. Expert witnesses were called. Butchers might testify about animal behavior. Priests might testify about signs of demonic possession. The strangest testimony came in a 1531 trial where witnesses claimed to have heard demons speaking to a possessed sow, threatening the town with plague if the pig was executed. The pig was executed anyway. There was no plague. Part 9. The ecclesiastical courts. While secular courts tried animals for crimes against humans, ecclesiastical courts handled animals that damaged property or disturbed religious life. These trials were different. Instead of execution, the punishment was usually excommunication or anathema. In 1516, the rats of Autun were formally excommunicated for eating the harvest. The bishop read the sentence. We warn and command you, harmful creatures, that within 6 days you must retreat from these fields and vineyards, never to return. If you disobey, we excommunicate you and curse you wherever you may go. Insects were common defendants. Locusts, caterpillars, beetles, all face ecclesiastical justice. In 1545, the wine growers of St. Julian brought charges against weevils destroying their vines. The trial lasted months. The insects were appointed a lawyer who argued they were following God's command to be fruitful and multiply. The court's solution was creative. The town must set aside a piece of land specifically for the weevils. If they stayed in their designated area, they could live. If they invaded the vineyards, they'd be excommunicated. A contract was drawn up. The weevil's lawyer rejected the first land offer as insufficient. Negotiations continued. A better plot was offered and accepted. The records claim the weevils moved to their new land and left the vineyards alone. Part 10. The rooster that laid an egg. Basel, 1474. A rooster was accused of laying an egg, an unnatural act suggesting sorcery. The trial was serious business. Roosters laying eggs were believed to produce basilisks, mythical serpents that could kill with a glance. The prosecutor argued, this cock has made a pact with the devil. The egg, if hatched by a toad or a serpent, will produce a basilisk that will bring death to our city. The defense lawyer argued brilliantly. My client has no control over its biological functions. If an egg was laid, it was through no will or desire of the accused. One cannot commit a crime involuntarily. He further argued there was no proof the rooster actually laid an egg. Perhaps someone placed an egg near the rooster to frame it. Witnesses testified they saw the egg emerge from the rooster. Others testified about the rooster's strange behavior, crowing at midnight, avoiding holy water. The defense made a final plea. Even if guilty of laying an egg, the rooster acted without malice. It couldn't understand the consequences. The judge disagreed. Whether through possession or corruption of nature, this creature has performed an act against God's order. The potential for great evil requires severe action. The rooster was sentenced to be burned at the stake along with the egg. At the executioner dramatically discovered 3 more eggs inside the rooster when he cut it open, likely planted. The crowd saw this as vindication of the verdict. Part 11. The Horse Murderers. Horses that killed humans faced particular scrutiny because they were valuable and usually gentle. In 1389 in Dijon, a horse kicked its owner in the head, killing him. The horse was tried for murder. The prosecution argued the horse had shown previous signs of aggression. It had bitten another man and kicked a dog. The defense argued the owner had been drunk and struck the horse first. It was self-defense. Witnesses testified about the relationship between horse and owner. Some said the owner was cruel. Others said the horse was bad-tempered. The court found the horse guilty, but showed mercy due to provocation. Instead of hanging, the horse was sentenced to be sold outside the jurisdiction, with the proceeds going to the victim's family. But there was a problem. Who would buy a murderous horse? The solution was to brand the horse with a mark indicating its crime, then sell to foreign merchants who didn't know what the mark meant. Part 12. The donkey's reprieve. Not all animals were convicted. In 1750 in Vannes, France, a man named Jacques Ferron was caught having sexual relations with a donkey. Both man and donkey were tried for sodomy, punishable by death. Ferron was quickly convicted and sentenced to death. But the donkey's case was different. The local prior and citizens signed a certificate stating, "We attest that the said she-ass has always shown herself to be virtuous and well-behaved both at home and abroad, and has never given occasion for scandal to anyone." The court accepted this character reference. The donkey was acquitted as an unwilling victim. Ferron was burned at the stake. The donkey was returned to its owner. This case shows that by the 18th century, courts were beginning to distinguish between willing participation and victimization, even for animals. Part 13. The mass trials. Sometimes entire species were tried collectively. In 1519, the commune of Glaris tried field mice en masse for destroying crops. All field mice, present and future, were defendants. The mice were ordered to appear in court. When they didn't, they were tried in absentia. The defense lawyer argued his clients couldn't all appear because many were ill, elderly, or pregnant. Furthermore, they had no way of knowing about the summons. The court ordered the summons read in the fields 3 times. Still no mice appeared. The lawyer then argued that even if guilty, his clients had the right to sustenance. God created them before he created private property. They were exercising ancient rights. The prosecutor countered that while God created mice, he gave humans dominion over animals. The mice must submit to human law. The verdict was compromise. The mice were given 2 weeks to leave. Pregnant and infant mice were given an extra 2 weeks. If they didn't leave, they'd be cursed with eternal damnation. Church records claim the mice left within the specified time. Part 14. The Dolphin Incident. Marseille, 1596. A dolphin was causing problems in the harbor, tangling fishing nets and allegedly attacking swimmers. The fishermen brought legal action. But this case was complicated. Dolphins were considered royal fish in France, under the king's protection. The trial had to determine, was this dolphin acting criminally or naturally? Was it actually a dolphin or a demon in dolphin form? Witnesses testified about the dolphin's behavior. Some claimed it showed intelligence and malice. Others said it was just playful. A priest testified that he tried to bless the dolphin with holy water, and it had fled, surely a sign of demonic possession. The defense, yes, the dolphin had a lawyer, argued that fleeing from someone throwing water was natural behavior, not proof of possession. The court reached an unusual verdict. The dolphin was banished from the harbor. If it returned, it would be harpooned. The town crier read the verdict at the harbor for 3 consecutive days, in case the dolphin was listening. The dolphin never returned. The town considered this proof that legal proceedings worked even on sea creatures. Part 15. The Cause of Justice. Animal trials were expensive. Towns kept detailed financial records. From Lausanne, 1451, for the trial of leeches. Judge's fee, 20 souls. Prosecutor's fee, 15 souls. Defense lawyer, 15 souls. Court clerk, 8 souls. Summoning the leeches, reading proclamation, at lakes 3 souls. Total, 61 souls, about 2 months' wages for a laborer. The trial of a pig in 1457 cost. Arresting the pig, 2 souls. Jail costs, 9 days at 2 deniers per day, 1 soul, 6 deniers. Cart to transport pig to trial, 6 deniers. Rope for hanging, 2 deniers. Executioner's fee, 20 souls. Gloves for executioner, 2 deniers. Building the gallows, 25 souls. Burial of the pig, for deniers. Some towns went bankrupt prosecuting animals. The extended trial of caterpillars in Villeneuve lasted 3 years and consumed the town's entire legal budget, but towns considered it worthwhile. These trials maintained cosmic order and demonstrated that law applied to all creation. Part 16, the prison conditions. Animals awaiting trial were kept in the same jails as human prisoners. Jail keepers charged the same daily rate for animals as humans, typically 2 deniers per day for food and straw. The conditions were recorded. A pig in Savigny was kept in a cell for 3 weeks, fed table scraps and water. The jailer complained about the smell and noise. In one case, a bull awaiting trial broke out of jail. It was recaptured and charged with attempted escape in addition to its original crime of goring a man. Some animals had visitors. Owners might come to feed their animals better food, hoping to keep them healthy for potential acquittal. There are records of animals dying in jail before trial. In 1516, a sow died in custody after 2 weeks. The trial proceeded anyway with the corpse as defendant. It was found guilty posthumously, and the body was publicly burned. Part 17, the international variations. Different regions had different approaches to animal trials. In Germany, animals were more likely to be tortured before execution, following German legal tradition for human criminals. In Italy, animals might be tried by the Inquisition if witchcraft was suspected. In Switzerland, animals were sometimes sentenced to exile rather than death, driven across the Canton border and forbidden to return. In Spain, bulls that killed in bullfights were exempt from prosecution. Their actions were considered part of legitimate sport. In England, while formal trials were less common, there was a deodan system. Any animal or object that caused death became property of crown, to be sold with proceeds going to charity. Eastern Europe had fewer animal trials, but more cases of animals being killed by mobs without formal proceedings. France had the most elaborate trials with the longest legal arguments and most detailed records. Part 18, the witness animals. In some trials, animals appeared as witnesses. In 1553 in France, a man was accused of murdering another. The victim's dog was brought to court. When the dog saw the accused, it allegedly barked and tried to attack him. This was taken as evidence of guilt. In another case, a parrot that could talk was brought to testify about a murder it supposedly witnessed. The parrot kept saying, "Kill, kill," but the court ultimately decided this wasn't reliable testimony. Cats were sometimes brought to witch trials. If the cat reacted negatively to the accused, it was seen as recognizing its demonic master. These animal witnesses were taken seriously. Their behavior in court could influence verdicts. Part 19, the symbolic punishments. Some animal sentences were clearly symbolic rather than practical. In 1685, a swarm of locusts was sentenced to be banished. The sentence was read in the fields. The locusts were given 3 days to leave or face divine wrath. When they didn't leave, the priest performed an exorcism ritual, sprinkling holy water and burning incense. The locusts eventually left, as they naturally would after consuming available food. The town celebrated the effectiveness of spiritual justice. In another case, termites eating church property were given a formal eviction notice. It was nailed to a tree they'd infested. They were given 24 hours to vacate. These symbolic acts weren't expected to actually communicate with animals. They were performances demonstrating human dominion and divine order. Part 20, the learned debates. Scholars seriously debated the philosophy of animal trials. Some argued animals had souls and moral agency. Others said they were automatons following instinct. The Jurispierro wrote in 1591, "If animals lack reason, how can they commit crimes? Yet if they cannot commit crimes, why does Scripture demand their blood for shedding human blood?" The theologian Francisco Suarez countered, "Animals participate in natural law through instinct. When they violate this law, they must be corrected, not for their understanding, but for the restoration of order." Universities held formal debates on questions like, can an animal commit heresy? Do insects have standing to own property? Can an animal be a legal witness? Is an animal's confession under torture valid? These weren't joke debates. Serious scholars produced lengthy treatises on animal jurisprudence. Part 21, The Decline of Practice. By the 1700s, animal trials were becoming rare. The Enlightenment brought skepticism. Voltaire mocked the practice viciously. We have hanged dogs and excommunicated caterpillars. Future ages will either pity our ignorance or envy our faith. The last recorded formal animal trial in France was in 1741, when a cow was convicted of sorcery. In 1750, the legal scholar Valentini wrote, that our ancestors seriously tried animals proves only that wisdom comes slowly to humanity. But the practice didn't end everywhere simultaneously. Switzerland held animal trials into the 1800s. Russia reportedly tried a goat for witchcraft in 1891. The transition was gradual. Courts stopped holding formal trials, but continued destroying dangerous animals through administrative procedures. Part 22, The Legal Legacy. Animal trials influence modern law in unexpected ways. The concept of legal standing, who can bring a lawsuit, was shaped by debates over whether animals could be plaintiffs or only defendants. The requirement for proper legal representation developed partly from animal trials, where lawyers had to seriously defend non-communicating clients. The principle that ignorance of law is no excuse was reinforced by arguing applied even to creatures incapable of understanding law. Modern animal rights law ironically draws on medieval precedents that animals can have legal status, even if not legal responsibility. Some legal historians argue that animal trials helped develop the adversarial system by forcing lawyers to make arguments for clearly guilty clients who couldn't assist in their defense. Part 23, The Psychological Interpretation. Why did rational people hold irrational trials? Modern psychologists suggest several reasons. Control. Trials gave people a sense of control over chaotic nature. If you could prosecute locusts, you weren't helpless against disaster. Justice. When animals caused harm, trials provided closure. The universe wasn't random. Wrongdoers were punished. Scapegoating. Animal trials let communities externalize guilt. Bad harvests weren't due to poor farming, but criminal insects. Performance. Trials demonstrated civic sophistication. Towns with elaborate legal systems could try anything. Faith. Trials affirmed religious cosmology, where all creation existed within moral law. The anthropologist E.P. Evans wrote, medieval animal trials weren't signs of ignorance, but of hyperextended logic. If law came from God and governed all creation, then all creation could violate it. Part 24, The Modern Parallels. We mock medieval animal trials, but modern society has parallels. In 2008, a monkey in India was declared the legal owner of itself to protect it from capture. In 2015, a New York court heard arguments about whether chimpanzees could have habeas corpus rights. The 2016 monkey selfie case debated whether an animal could own copyright. Rivers, mountains, and forests have been granted legal personhood in various countries. We still symbolically punish objects, destroying drug money, crushing racing cars used in crimes, demolishing houses where murders occurred. The medieval impulse to bring nature into our legal framework persists, just in different forms. Part 25, The Surviving Records. Detailed records survive from over 200 animal trials. The Archives Nationales in Paris has complete transcripts of pig trials, including witness testimony and legal arguments. The Vatican's secret archives contain records of ecclesiastical proceedings against insects, with theological justifications for excommunicating locusts. Swiss cantonal archives preserve expense accounts showing exactly how much it costs to try and execute animals. These records are valuable not for what they say about animals, but what they reveal about human society, its fears, beliefs, and need for order. The historian Esther Cohen notes, animal trials are windows into medieval mentality. They show people struggling to make sense of a dangerous world through the tools they knew, law and faith. Part 26. The Art and Literature. Animal trials inspired art that survives today. The Church of the Holy Trinity in Falaise had a fresco of the 1386 pig execution, though destroyed in 1820. Sketches survive showing the pig dressed as a man on the gallows. Illuminated manuscripts depict animal trials, complete with suited pigs and rats consulting with lawyers. The poet Bartholomew Chassenée wrote the Order Judiciary against Rats in 1550, satirizing the trials while acknowledging their legal complexity. Medieval mystery plays included scenes of animals being tried, mixing comedy with genuine legal procedure. These artistic representations weren't mockery. They were affirmations that even animals existed within divine justice. Part 27. The Children's Attendants. Parents brought children to animal executions as moral education. A father's diary from 1457 records took young Pierre to see the sow hanged. He must learn that all who spill human blood must answer for it, whether man or beast. Children were taught that these trials demonstrated God's justice extending throughout creation. Some children were traumatized. Others found it exciting. Most accepted it as normal. There are accounts of children playing animal trial, putting their pets through mock proceedings, though usually acquitting them. This childhood exposure perpetuated the practice. Children who grew up seeing animal trials became adults who conducted them. Part 28. The Gender Aspects. Female animals were sometimes treated differently than males. Pregnant animals often received stays of execution until after giving birth, following human legal precedent. In one case, a sow with piglets was convicted of murder. The sow was executed, but the piglets were given to a monastery to raise, as they were considered innocent orphans. Female animals accused of sexual crimes were more likely to be seen as victims rather than perpetrators. But female animals accused of witchcraft were treated as harshly as human witches, burned at the stake. The she-ass acquitted in 1750 benefited from character witnesses testifying to her virtue, language usually reserved for women's honor. Part 29. The Final Cases. The last clearly documented formal animal trial in Europe was in 1741, when a cow in France was hanged for sorcery. But informal quasi-legal proceedings continued longer. In 1891, a Russian goat was reportedly tried for witchcraft, though records are fragmentary. In 1916, in Tennessee, Mary the elephant was hanged from a railroad crane for killing her handler. While not a formal trial, there was public deliberation about her guilt and appropriate punishment. Even today, when dangerous dogs are put down, there are often hearings with evidence presented and owners able to argue for their pets' lives. The impulse to apply legal process to animal behavior never fully disappeared. Part 30. The Meaning of Justice. What did medieval animal trials mean for concepts of justice? They suggested justice was universal, not just human convention, but cosmic law. Every violation required response, whether by human or beast. They implied moral order was fragile. Even animal misbehavior could threaten social stability. They demonstrated law's power. If courts could judge animals, surely they could judge any human. They revealed deep anxiety about nature's chaos and humanity's place in creation. Most fundamentally, they showed that justice was performance as much as principle. The elaborate ritual of trying animals reinforced the legitimacy of trying humans. When we condemn medieval animal trials as absurd, we might ask, what current legal practices will seem equally absurd to future generations? The medieval world that seriously tried rats and hanged pigs was the same world that developed jury trials, legal representation, and due process. Perhaps animal trials weren't a deviation from legal development, but part of it, the growing pains of a legal system learning its boundaries. Or perhaps they were simply what happens when people apply rigid logic to an illogical world, seeking order in chaos through the only tools they trusted, law, faith, and the gallows is so tonight. As you drift off to sleep safe in your bed, be grateful that if your pet misbehaves, They won't face a jury of their peers. The medieval world that put pigs on trial for murder and appointed lawyers for rats seems impossibly absurd to us now. But for 500 years, educated judges, trained lawyers, and rational people seriously believed that animals could commit crimes and deserve formal trials. These weren't witch hunts or mob justice. These were careful legal proceedings following established precedent and procedure. The same courts that tried humans tried animals with equal seriousness. Perhaps the strangest part isn't that they held these trials, but that they believed they worked. Towns celebrated when excommunicated locusts left. Cities credited legal proceedings when rat infestations ended. We've traded medieval absurdity for modern rationality. Or have we? We still sue corporations as if they're people. We still seize and destroy objects used in crimes. We still perform elaborate legal rituals that sometimes seem as symbolic as reading an eviction notice to termites. The medieval world at least had consistency. If all creation was under God's law, then all creation could break it. Sleep well, and if you hear your cat plotting in the night, don't worry. These days, they'd probably just get a good lawyer. Sweet dreams.